One of the reasons I like answering questions is they prompt me to look at things I hadn't thought about before. Take, for example, the recent request I had to review the Federal Tort Claims Procedure. While I review lawsuits regularly here, I'd never taken the time to look at this particular legislation. So we'll do so next on the Constitution Study.
Neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution, teach our next generation to be free. I'm glad you could join me today. Okay, tort claim procedure doesn't sound terribly exciting, although there is some interesting information in here, especially if you think you have a claim, an injury from the federal government. I'm going to talk more at the end about the website and other ways you can support the work that we're doing here, but take some time. Let's look into these federal tort claims and what's the procedure for them and why is it important? Let's start with defining the term tort. From Webster's 1828 dictionary, we find that a tort is, in law, any wrong or injury. Torts are injuries done to the person or property of another as trespass, assault and battery, defamation, and the like. So a tort is a wrong or an injury, a grievance, you might say. Now, hopefully that comparison should remind you of the First Amendment, which reads, Congress shall make no law abridging the right of the people to petition the government for a redress of grievances. Tort technically is the wrong or injury, while tort claims refer to the seeking of redress of that grievance. The Federal Tort Claims Procedures is the statutory law Congress passed to regulate tort claims against the federal government. The procedures used for the federal tort claims are contained in Chapter 171 of Title 28 of the United States Code. After the definitions, the law starts with what are called administrative adjustments. From Section 2672, we read, the head of each federal agency or his designee, in accordance with regulations prescribed by the Attorney General, may consider, ascertain, adjust, determine, compromise, and settle any claim for any damages against the United States for injury or loss of property or personal injury or death caused by the negligent or wrongful act or omission of any employee of the agency while acting within the scope of his office or employment under circumstances where the United States, if a private person, would be liable to the claimant in accordance with the law of the place where the act or omission occurred. Section 2672 basically says that the head of each federal agency can settle claims for money damages against the United States for injury, loss, or even death. That means if you have a tort, a claim of injury against the United States, the head of the agency responsible can negotiate and settle rather than going to court. Of course, they can only settle if you agree to the settlement. Let's talk about the line, under circumstances where the United States, if a private person, would be liable. See, under the law, you have natural and artificial persons. You and I are natural persons, while corporations are artificial. Under this law, the United States is just as liable as a natural person would be in that same situation. If you could sue your neighbor for a tort, you can sue the United States for the same tort. Continuing, we read, any award, compromise, or settlement in an amount of $2,500 or less made pursuant to this section shall be paid by the head of the federal agency concerned out of the appropriations available to that agency. Payment of any award, compromise, or settlement in an amount in excess of $2,500 made pursuant to this section or made by the Attorney General in any amount pursuant to Section 2677 of this title shall be paid in a manner similar to judgments and compromises in like causes and appropriations or funds available for the payment of such judgments and compromises are hereby made available to the payment of awards, compromises, or settlements under this chapter. Okay, another stipulation in this section of the code is how payments are made based on their size. $2,500 or less and the agency pays directly. More than $2,500, or if the award is made by the Attorney General, it's handled the same way any other legal settlement would be paid. Section 2673 of the Act reads, the head of each federal agency shall report annually to Congress all claims paid by it under Section 2672 of this title. stating the name of each claimant, the amount claimed, and the amount awarded, and a brief description of the claim. See, Congress holds the power of the purse, or as Article 1, Section 9 states, no money shall be drawn from the Treasury but in consequence of appropriations made by law, and a regular statement and account of the receipts and expenditures of all public money shall be published from time to time. Even though an agency may pay a claim of $2,500 or less out of its existing appropriations, they still have to report to Congress on the expenditure so they can be properly published. Next, in Section 2674, we read, the United States shall be liable respecting the provision of this title relating to tort claims in the same manner and to the same extent as a private individual under like circumstances, but shall not be liable for interest prior to judgment or for punitive damages. As stated before, the United States is just as liable to tort claims as a private individual. However, it cannot be liable for interest prior to judgment. Considering that civil cases against the United States can take years to be decided, this said interest could add up to quite a lot of money. What this means is that the United States pays no price for delaying or otherwise slowing down the judicial process. I wonder if the reciprocal law is in effect. If the United States sues you, are you liable for interest prior to judgment? Also notice, this claims that the United States is not liable for punitive or punishing damages. We'll get into that a bit more later. If, however, in any case wherein death is caused, the law of the place where the act or omission complained of occurred provides or has been construed to provide for damages only punitive in nature, the United States shall be liable for actual or compensatory damages measured by the pecuniary injuries resulting from such death to the persons respectively, or whose benefit the action was brought in lieu thereof. Now, if the claim involves a wrongful death where the injury happened matters, if that location only allows for punitive or injury damages, the United States shall be liable for the actual or compensatory, the replacement damages. Those damages are to be measured by the pecuniary or monetary injuries resulting from the death, but only in a situation where there's a death and punitive damages are the only thing that's available. With respect to any claim under this chapter, the United States shall be entitled to assert any defense based on judicial or legislative immunity which otherwise would have been available to the employees of the United States whose act or omission gave rise to the claim, as well as any other defense to which the United States is entitled. The United States is entitled to assert any defense based on judicial or legislative immunity available to an employee of the United States. Now, legislative immunity comes from Article 1, Section 6, which reads, the senators and representatives, for any speech or debate in either house, they shall not be questioned in any other place. You cannot sue a senator or representative for what they say in either house. Similarly, judicial immunity protects judges from suits for their judicial acts. Now, there's just one problem with this section of the law. There is no constitutional authority for judicial immunity, and legislative immunity is limited to senators and representative speech and debate. So the United States does not have legislative or judicial immunity, and neither do any of its employees. Speaking of constitutional issues, with respect to any claim to which this section applies, the Tennessee Valley Authority shall be entitled to assert any defense which otherwise would have been available to the employee based upon judicial or legislative immunity, which otherwise would have been available to the employee of the Tennessee Valley Authority whose action or omission gave rise to the claim, as well as any other defense to which the Tennessee Valley Authority is entitled under this chapter. The Tennessee Valley Authority, or TVA, is an unconstitutional, federally owned power corporation. It should surprise no one that Congress tries to protect its illegal creation with such language. Before a person takes the United States to court, Congress wants them to at least attempt to resolve the issue with the offending agency directly. An action shall not be instituted upon a claim against the United States for money damages for injury or loss of property or personal injury or death caused by the negligent or wrongful act or omission of any employee of the government while acting within the scope of his office or employment, unless the claimant shall have first presented the claim to the appropriate federal agency and his claim shall have been finally decided by the agency in writing and sent by certified or registered mail. The failure of an agency to make final disposition of a claim within 6 months after it is filed shall, at the option of the claimant any time thereafter, be deemed a final denial of the claim for the purposes of this section. The provisions of this subsection shall not apply to such claims as may be asserted under the Federal Rules of Civil Procedure by third-party complaint, cross-claim, or counterclaim. First, a person has to present their claim to the appropriate federal agency. As one might expect, the agency may find reason to, delay their response to some of these claims. That's why there's a 6-month time limit before a de facto denial takes effect. Now, what would legislation about holding government actors accountable be without a series of exceptions? The provision of this chapter and Section 1346B of this title shall not apply to any claim based on an act or omission of an employee of the government exercising due care in the execution of a statute or regulation, whether or not such statute or regulation be valid, or based upon the exercise or performance of the failure to exercise or perform a discretionary function or duty on the part of the federal agency or an employee of the government, whether or not the discretion involved be abused. So a government actor who's executing an invalid law or regulation cannot be sued under this act. Now, on the one hand, if the government employee has been told what they're doing is legal, I can understand this. Still, don't government employees have a duty to support the Constitution? Shouldn't they be held accountable for their unconstitutional acts, even if the law says it's okay? Any claim arising out of the loss, miscarriage, or negligent transmission of letters or postal matter. You cannot sue the United States for the failures of the Postal Service. Any claim arising in respect of the assessment or collection of any tax or custom duty, or the detention of any goods, merchandise, or other property by any office of customs or excise or any other law enforcement officer, except that the provisions of this chapter in Section 1346B of this title apply to any claim based on injury or loss of goods, merchandise, or other property, while in the possession of any officer of customs or excise or any other law enforcement officer. Neither can you sue based on the assessment or collection of any tax, to the detention or confiscation of any goods or merchandise. Now, there's a long list of specific exceptions for property in the possession of law enforcement officers. I won't bore you with the legalese. To summarize, property seized under forfeiture, interest on claims, claims against the operations of the Treasury or military forces, and the Tennessee Valley Authority or Panama Canal Company are all exempted from claims under this act. What conclusions can I draw from this review of the Federal Tort Claims Procedures Act? Most of it appears to be cut and dry legalese designed to show a level of accountability without exposing the federal government to tort claims for the more serious constitutional violations. The exceptions listed in Section 2680 does seem to violate the Petitions Clause of the First Amendment, which reads, Congress shall make no law abridging the right of the people to petition the government for a redress of grievance. After all, it lists situations where people cannot sue even though they have a tort, an injury, or a wrong. That said, I don't believe the Act even approaches the worst violations of the Constitution that Congress has passed. So that's my review of the Federal Tort Claims Procedures Act. Mostly legalese, stuff that kind of makes sense, although I am concerned about Congress exempting itself in violation of the First Amendment. Something worth considering. As I said, in the list of unconstitutional things Congress has done, this is not in the top half. But it's just something to be aware of. I mean, obviously, if you have a tort, if you have a claim against the United States, and this law is preventing you from following it, you could certainly challenge it under the First Amendment, since Congress made this law that said you can't sue somebody for damages caused even for implementing an unconstitutional law or regulation. Certainly seems to be a problem there to me. For the rest of it, I hope it answered the question. As I said, I like questions because questions get me to look at things I might otherwise not have. I probably never would have looked at this if someone hadn't asked a question. Which reminds me, if you want to ask a question, if you'd like me to review something, or you have a case or some other thing you want me to talk about, well, go to constitutionstudy.com/questions and simply ask. I just name, email address, and then ask your question. I also answer questions on the radio program. You can hear that on America Out Loud. And if you'd like me to answer a question there, there's a checkbox for that. But I think questions are vitally important. Questions are how we learn. And don't worry, to me, there are only two stupid questions in the world. The one you don't ask, and then the one you ask 3 times. If you don't know, ask. I'm not going to embarrass somebody because they're not as familiar with constitutional issues as I am. I've spent years studying this. If you ask, all I ask is that you listen and learn. To ask me the same question over and over again, you're not paying attention, that to me is a foolish question. There's a lot of ways you can learn. One way you can learn is a study guide. I found this course called The Miracle of America. It's really cool. It deals with our history leading into and continuing through the constitutional period. Now, I made a deal with the owners to get you a free lesson. So if you go to constitutionstudy.com/1776 study guide, you can check out the course, but you can also enroll for a free lesson. It's a lesson on God's natural law. Absolutely free. If you like it, you can buy the entire course for just $17.76. But it's worth giving it a try, and it's worth trying the free, even if you decide not to buy it in the long run. So again, the website is constitutionstudy.com/1776 study guide. I think you'll like it. You get a downloadable PDF. You can watch a video. You can listen to it on audio. I think you'll like it, and I think you'll find it worth paying that $17.76 to get access to the full course. There are a lot of things you can do to defend your rights, one of which includes using your cell phone. Patriot Mobile is America's only Christian conservative wireless provider, and they believe what we believe. They support our rights protected by the Constitution. Freedom of speech, freedom of religion, the right to life. They help support those organizations that are protecting those rights, those ideas. So when you get your cell phone service, your wireless service from them, you're helping support people that are protecting our rights as opposed to others which may be out to destroy our rights. If you join today, use the code Constitution at checkout, you'll even get free activation. So the website is patriotmobile.com/Constitution. Be sure to use the code Constitution at checkout to get free activation. You can also just share the work we're doing here. Share links to this episode, to the articles, to the web page, or just share. Sharing is one great way to let other people know that there's a service out here called the Constitution Study to help you read and study the Constitution and teach your rising generation to be free, to help you prepare to defend and assert your rights. Also, maybe you'll bring someone along and join us here the next time for the Constitution Study.
Love your neighbors and have a few good friends.